Tony. Good afternoon, everyone. As Tony said, I'm Teresa Phillips. I'll be presenting today with fiduciaries. Don't fall into the COVID trap. COVID's back in the news after a little bit over a year of having COVID in our lives, about a year and a half now. We're starting to see some issues that have slowly developed and come up in the area of fiduciaries and the fulfillment of their duties, their legal and fiduciary duties, and how COVID has specifically affected that. And so we're taking the time today to kind of start back, look at what a fiduciary has to do and how COVID has and can affect that, and maybe and also go through some practical advice on what fiduciaries and those of us that advise them should think about and when dealing with folks who either the persons or their income are affected by our life now that's governed by COVID and certain regulations and rules. So that's the purpose of today. It's going to be a lot of let's review the laws. Let's look at what our clients or our fiduciary should be doing, but then let's take a practical approach and look at how COVID may affect that, may challenge that, and maybe practical ways to work around that. And with the ultimate goal of not shouldn't let COVID or anything else for that matter be an ultimate excuse not to fulfill your duties, but maybe fiduciaries and those of us who advise them, we might have to become a little bit more active and aggressive and maybe sometimes imaginative on how we advise going forward. So thank you for joining us today. And as always, we love questions. Alrighty, let's get started here. Let's look at what our specific agenda is going to be today. Florida fiduciaries and the general duties owed. So we're going to start back in the beginning. What are the typical kind of fiduciaries we have here in Florida, and what are the specific duties they owe, and to whom do they owe them to? So we're going to look at three main types that usually come up: trustees, guardians, and personal representatives. Then we're going to look at what duties are most often affected by COVID, and why they're affected by COVID. We're going to look at some of the potential legal ramifications of that. We're also going to look at the adopted and the considered laws and rules that under Florida legislature right now that may assist fiduciaries. As I was preparing these materials, one of those laws were passed. It's commonly known as the Immunity Shield Law for COVID, and we're going to take a little closer look at that and see how it may assist you as an advisor or as a fiduciary. And then we're going to, as always, we like to include as much as possible practical advice and some practical thoughts on dealing with these issues. We'll have a section on that. And then we'll wrap back up with kind of our purpose of having this webinar today, which is try to avoid that trap of just saying, well, it was because of COVID. COVID, made me do it. And then, as always, we'll conclude with another opportunity to ask questions. So in Florida, there's three most common kind of fiduciaries are trustees, personal representatives, and guardians. Trustee is an appointed person under someone's trust. It's usually a person. It can also be a bank, a corporation. They're usually in charge of assets and deal less with the personal of supervising the person or something like that, or making personal decisions for anyone. But they're usually their main duty is to manage assets, manage it in good faith, and manage it for the benefit of the beneficiaries under the trust, whatever the trusted documents are that govern that trust. Personal representative is similar to a trustee. In fact, Florida law says they have the exact same duty as the trustee, except their duty is to a person who is now deceased in their estate, and people who benefit are the beneficiaries under that estate. So in both trustee and personal representative, you're dealing with primarily duties to manage assets, income, and distribute those things. The main difference is trustees are not under the supervision of the court. Personal representatives are. So they gain their authority from a court order, and they are limited their authority under Florida law and whatever the court orders. Trustees limitations are under Florida law, but governed more specifically under the trust document. Guardians are a little different. Guardians are people who are put in place, sometimes can be professional or companies, but they're put in place to manage two things. And sometimes it can be a different person that manages each of these things. The two things are property and the person. Normally a trustee or personal representative is not making decisions about a person's personal decisions, such as health, where they live, where they go, who visits them, what are their personal activities. But a guardian, because they're dealing with an incapacitated person, oftentimes has to make those decisions. And in that role, they're called guardian of the person. Now, they also have a role, or another guardian's appointed to have this separate role, but someone's also the guardian of the property. And in that sense, they're a lot like the trustee and personal representative. They have a duty of care to manage the assets, but they're strictly governed under the supervision of the court, even more so probably than personal representatives. And they're a lot more limited authority on what they can do with assets without court approval. So keep that in mind. A guardian probably in this context has a little bit more of a broader duty, because they're responsible for the person and the personal care of the incapacitated person, not just their assets. Okay, so we've got three different kind of roles here of fiduciaries, but a lot of their duties are very much in common. They all have a duty of good faith. That's probably the primary duty. Act in good faith. Administer, make decisions as you would if it was for your, it was for your own, the management of your own assets and things of that sort. You have a duty of care. You have a duty of loyalty. You have a duty, prudent investor rule applies to all these. If you're going to invest money, you have to do it prudently. And there's a whole section of the statutes that govern that, because that's so important to make sure that money isn't wasted. You have a duty to manage the assets and the monies. You can't, you have to go collect rents. You have to make sure that, if there's a rental property, it's income producing, or you have to make sure that the monies are in an account that are earning interest and things of that sort. You have to account for what you do. All of these, to a certain extent, are required to account. There's some waivers available, but generally speaking, you have to keep receipts and you have to account for everything you've paid out. And you have to avoid conflicts of interest. In some of these roles, it's easier than others. Sometimes when you're a personal representative, you're one of 5 kids who are all beneficiaries, so it's a little harder. But typically speaking, you should not involve yourself in decisions where you have a personal interest, and avoid those at all costs. And that kind of is the flip side of the duty of loyalty. You put the person that you have a fiduciary duty to above all else in making your decisions and managing the assets or making decisions for the person here. So while we're dealing with 3 different beneficiary, or 3 different kind of fiduciaries, we're dealing with similar duties here, and all of which may have been affected in the last year and a half by COVID. So before we move on to that, well, try to understand you have all these duties, and depending on the nature of the assets, the type of person that the guardian may be dealing with, these duties may consume a lot of time, a lot of effort. They may consume a little bit. It depends on the circumstances. And in that vein, there's some permission and authority to delegate certain duties. So let's look through that, because I think that may have become a more important issue during COVID than probably any other time in recent history. Is can I delegate some of these things given the circumstances? So delegation of duties for trustees governed by statute 736.0807. And what it says, it has very specific circumstances for a trustee delegating. And remember, when we're dealing with trust, this is the default rule. The trust instrument itself may have something else that may have authorized, but this, presuming there's nothing else in the trust instrument that's at issue, this is what a trustee can do when it comes to delegating duties. A trustee may delegate duties and powers that a prudent trustee of comparable skills could properly delegate under the circumstances, including investment functions pursuant to section 518.112. And the trustee shall exercise reasonable care, skill, and caution in selecting an agent, establishing the scopes and terms of the delegation, and they must be consistent with the purposes of the terms of the trust, and reviewing the agent's actions periodically in order to monitor the agent's performance and compliance with the terms of the delegation. And in performing a delegated function, an agent owes a duty to the trust to exercise reasonable care to comply with the terms of the delegation. A trustee who complies with subsection 1 And when investment functions are delegated, subject to statute 518.112, that trustee is not liable to the beneficiaries or to the trust for an action of the agent to whom the function was delegated. Okay, so as you can see from here, and I'll go back in subsection 1, if you use some exercise reasonable care and skill in selecting the agent and establishing a scope in terms of the delegation that are consistent with the purposes of the trust, and you review those agents' actions periodically to ensure compliance and performance, you're going to be excused from any breach that may be caused by that agent to whom you delegated to. In my experience, one of the things trustees delegate a lot is investment decision making. Professional managers of money and things of that sort. They use property managers to manage properties a lot of times. Those are probably the two most common ones I see as using agents to carry out functions. And both those examples, usually those individuals are money managers, property managers are used to dealing with that function, and you have agreements that set out the scope, and it's easy to review their actions periodically because you get monthly or quarterly statements, and so those kind of things are probably pretty common. But outside of that, outside of using those two functions, maybe a trustee is not used to delegating. And if you do, and maybe those people aren't used to having been an agent, a delegated agent. So I think probably the most important thing here is selecting an agent with care and establishing those terms, having written terms of what is the expectation, what is their scope, and what you expect from them, and how they must act to comply with the terms of the trust. You need not to just gloss over this, because this is your get out of jail free card over here, subsection 3. You have to comply with those, not if you don't want to be responsible for that agent's breach later on, if that should happen. All right, so the trustee has a specific way to delegate. Personal representatives, generally speaking, under the code, personal representatives aren't allowed to delegate a lot to other persons or entities related to its personal duties, but they are allowed to employ attorneys, accountants, real estate agents, and other professionals to assist them in representing and protecting the estate. When you're a personal representative, you have a personal duty to perform the responsibilities of an estate personal representative. But you also have a duty to supervise those who you may delegate ministerial tasks that are administrative and do not involve major decision making and use of discretion. So in total, a personal representative has to make the decisions, but they can delegate some of the tasks to other professionals to assist them with that. What are some of the common examples of personal representatives using others? Attorneys, accountants, almost always. Rarely have I seen a personal representative prepare the tax returns, unless they just happen to be in that field. But they ultimately are responsible for the decision making and what those professionals file and put together. Okay, so section 733.612, subsection 19 of the Florida statute gives the personal representative the express right to employ persons, including but not limited to attorneys, accountants, auditors, appraisers, investment advisors, and others, even if they are one and the same as the personal representative or are associated with a personal representative, to advise or assist the personal representative in the performance of administrative duties. And they can act upon the recommendations of those employed persons without independent investigation, and instead of acting personally, employ one or more agents to perform any act of administration, whether or not discretionary. Any fees and compensation paid to a person who is the same as associated with or employed by the personal representative shall be taken into consideration and when you determine the personal representative's compensation. So here you see that they're specifically allowing the personal representative to hire someone to prepare the taxes, hire someone to make valuations and things of that sort. And if you're not, even though you're allowed to do it yourself or people you're associated with, if you hire the professionals, you certainly can pay them. That means now, if you're the personal representative that's delegating or employing people to do all these tasks that might affect your compensation. If you've paid an extraordinary amount to perform all these functions, certainly it probably will. But that's the kind of relationship with others that the probate code anticipates, that you're going to employ people to do certain administrative tasks that have to be performed, and you can rely upon those, but it's going to affect your compensation. So what is a guardian's ability to delegate? Well, Section 744.442 Florida statutes actually provides for a surrogate guardian to be designated. And this is anticipated when a guardian is unable to act for whatever reason, but it kind of anticipates a temporary inability to actually do the task directly. So this is what the statute says. Subsection 1, a guardian may designate a surrogate guardian to exercise the powers of the guardian if the guardian is unable to act. A person designated as a surrogate guardian under this section must be a professional guardian. So if you've been, appointed as, your uncle's guardian, you can't appoint your spouse, but you can designate a professional. The only time that I've seen this come up is in the context of someone's going to have surgery and be, down for a period of a couple weeks, maybe a month, or they're leaving the country for some reason. Things like that are going to be outside the jurisdiction, and they want to have someone who can make, decisions while they're gone. So subsection 2 says a guardian must file a petition with the court requesting permission to designate a surrogate guardian. So you can't just unilaterally do it. The court needs to oversee it and make sure they approve whomever you've selected, whatever professional guardian you've selected. If the court approves the designation, the order must specify the name and business address of the surrogate guardian and the duration of appointment, which may not exceed 30 days. These are intended to be temporary. The court may extend the appointment for good cause shown. The surrogate guardian may exercise all powers of the guardian unless the court has limited it by order. The surrogate guardian must file with the court an oath swearing or affirming that he or she will faithfully perform the duties delegated. The court may require the surrogate guardian to even post bond. This section does not limit the responsibility of the guardian to the ward and to the court. The guardian is liable for the acts of the surrogate guardian. The guardian may terminate the authority of the surrogate guardian by filing a written notice of the termination with the court. The surrogate guardian is subject to the jurisdiction of the court as if appointed to serve as guardian. So I think the most important thing to take away from there is if a guardian chooses to use a surrogate, they're going to remain liable for the acts of that surrogate guardian. So choose wisely and probably only choose to do so when it's necessary. Again, the only context I've ever seen it done properly in is when someone, like I said, is having surgery or has to be out of the country and unavailable for a certain period of time, maybe related to work. And I have seen it done improperly where someone just, you call a guardian for something and they say, well, he's not here, he's out of town, but I'm his wife, I'm handling that now. That's improper. But the proper way to do it, is to choose your professional guardian and have the court approve them, and then hope they don't mess anything up, so you're not called in to be responsible for that as well. So now we know these three fiduciary types of fiduciary duties, fiduciaries. They also, in addition to having the duties, they all, at least to a limited extent, have an ability to delegate or use other persons to help them in the fulfillment of these duties. So now let's take that into the context of COVID. If you're watching this webinar, I can't believe you don't know what COVID is, or don't know how it's affected our lives for the last 18 months or so. It's a pandemic. It's been declared a federal emergency, states emergencies. We've had all kind of orders come out of Florida and our local communities, our local government authorities at different times, restricting where we can go, who we can visit, what we have to, if we have to wear a mask or not wear a mask, if we have to socially distance. All those things at different various points in the last 18 months has affected everybody to some degree. We also had federal CDC guidelines that came out that restricted, for a while, certain elderly people and people in risk categories had, there was more recommendations that they stay away from other people and not interact, and that there was limitations on their visitors and the people who interacted with them. We've all, if you're in any kind of legal field, you've learned how to use Zoom and the other kind of platforms to virtually appear in court or other proceedings, or even meetings with our own clients now. So all these things, have become part of everyday life in the last 18 months. And so fiduciaries have had to adjust to what they normally do with their normal, administration, the normal carrying out of their functions. They've had to continue, they've continued to have those duties for the last 18 months. I've seen no court order or state order or anything that just relieved fiduciaries of their duties. So those duties have stayed in place, and fiduciaries have been tasked with trying to adjust and in the world of COVID and with the restrictions that it imposed. So what if you have a duty to the person? Usually that's just the guardian, like we talked about. Well, your duties to the person probably were governed most likely during the COVID period by whatever the local health and CDC guidelines were saying at the time. We all remember there was a time over a few months where no visitations to elderly care facilities, could be had. There was no direct contact. They were, essentially shut down and limiting, who could come in and out to employees, essential employees at that, to protect that community that was particularly at risk. So those guidelines were pretty strict. They were lifted at some point. And then of course, we've all been subject to masking and distancing, guidelines and things of that sort, which is, all work to keep personal contact to a minimum, especially with groups of high risk, such as elderly folks. So, so that if you've had a duty to the person, such as a guardian, you've had to adjust how you handle things. For example, a guardian has actually has a statutory obligation to physically visit, or someone from their office to physically visit the person and check on them periodically. Obviously, you can do this during the CDC shutdown, when those guidelines were in place. So did you call? Did you try to Zoom? Did you, how could you, essentially try to fulfill that duty when you physically couldn't, be in the room or visit with them? People did it differently. I've heard some that called, talk to the staff, try to talk to the person directly. Sometimes that's not an option, depending on what kind of state they're in. They, try to receive reports, pictures, ask staff to take pictures, things of that sort, in an effort to comply with that requirement. But mostly during that time period, that those strict guidelines were restricting personal contact, you were having to defer to CDC guidelines and whatever the local statutes were saying. Now, how about duties to the property? How were they affected by COVID? Well, I've listed out some of the most common things you have to do with regards to your obligations to property, to a third person's property. And then, now we're going to look at how COVID may have affected those. You have a duty to protect assets. And oftentimes that requires personal inspection, especially if you have rental properties and things like that can require maintenance or can depreciate with harm or waste. Even if you have managers, you have a duty to make sure there's some kind of physical inspection, at least periodically, to see has there been damage to one of the properties, and things of that sort, or have the tenants damaged it, or is there a need for some kind of maintenance? So that requires a physical trip to the property to see things, and maybe even require some limited interaction with other people if they're living there or managing the property. You have a duty to produce income from those assets. During COVID, we had all kind of tenant restrictions. We still do to a certain extent. You couldn't evict people in personal property situations. So what if they're refusing to pay rent and you can't evict them? But you have a duty to produce income from assets. So you can imagine how that could wreak havoc with a beneficiary or with a fiduciary. And then you also have a duty to pay bills, including taxes, which, for most people that are using tax professionals, that requires some interaction. It requires you to go gather documents and things of that sort. Luckily, the federal government, and I presume most state governments that require tax filings, gave extensions for those just for that very reason, to give people more time to figure out more safe ways to exchange information and things like that. And then we had some changes to the tax code, temporary changes to the tax code during the year of 2020 that may have affected how fiduciaries manage assets or what they may put on the filing of the taxes. So with all this in the background, thinking that these are the basic duties to any property, let's look at some common scenarios that the fiduciaries faced and may still face. We just touched on tenants not paying. That's probably been a big one. And that's not just fiduciaries who are managing properties for others, but anybody who's renting property they're affected by it and probably still affected by it. What if you just happen to be in between tenants? What was your duty to go find a new tenant, even though maybe you personally didn't want to be out out and about. You didn't want to interact with people, interview potential tenants. Didn't want to have to go with tenants to show properties and things of that sort. How did maybe that change things for you as a fiduciary who may be managing the property? Did you take advantage of tax extensions and the changing rules? There was some changes to how investment accounts could be. I know there was a rule about the required minimum distribution to certain held assets. Those were waived during 2020. Did you take advantage of that, or talk to the accountant and determine if that was something you wanted to do or shouldn't do? Those were all decisions that were having to be made. And some of these things, they were changing weekly. The deadline kept being extended and things like that. We certainly have had a volatile market during times of COVID, especially in the beginning, and then things get better and then things get worse. And then so what were some of the strategies you may have employed that you normally wouldn't employ, probably after talking to an investment manager? How did you deal with the lack of communication? Like we just said, I mean, everything was designed to keep us from as people as people from interacting with other people, having personal interaction. When your everyday duties probably required some extent of personal interaction. If nothing else, like I said, dropping off, records to professionals or picking up rent checks. So how quickly were you able to accommodate these new changes and figure out other ways to, continue with your duties? Zoom has become, the standard for everyone in a professional sense, in a working sense, but you got to remember, a lot of these people that that fiduciaries are in charge of, either personally or because of their property, these are a lot of times elderly people or mentally ill people, or people with other issues, disabilities and limitations. Zoom may not be for them, and especially if they're they're in a elderly care facility that's essentially locked down. You can't get Zoom equipment in there overnight. So what did you do if that wasn't an option, if there wasn't an easy solution with the Zoom or the phone? What other ways were you able to communicate with them? And then what if you had a lack of available healthcare issue during this time? If you had especially with a person who was sick, and healthcare was limited, they weren't taking, there was a point where they stopped taking anything that wasn't essential. And I was surprised myself to learn what's considered essential healthcare and essential procedures. Basically, if you don't have this procedure today, you'll die is the definition, I think, of essential. But that doesn't mean that maybe they still need their new hearing aids. Maybe they still need, they have planned cataract surgery that was postponed, and it's affecting their, care and their ability to, to be cared for. And so all these issues, as you can imagine, could have been developing depending on your situation as a fiduciary, and you were having to make quick decisions on how to adjust them. Because like I said, I don't think there was ever any blanket excuse from complying with your duties. Fiduciaries were still charged with figuring out a way to comply with these duties at all times, at least as reasonably as they could. So that's just a few of the scenarios. If anyone else has any examples they'd like to share with us, feel free to, and we'll discuss them in the end here. But I think those are the most common ones I saw personally or heard about, and I think you can imagine scenarios that could affect trustees, guardians, and/or personal representatives. And that's not even getting into the deadlines that a lot of these fiduciaries have, such as personal representatives have to close the estate within a year and things of that sort. Guardians have to make certain reports and accountings and on a yearly basis. And if COVID, hit at the right time, it was probably nearly impossible to gather the information, get it to a professional, and get that done under those deadlines. Why do we care? Well, breach of fiduciary duties is a pretty serious offense. Nobody wants to be charged with it. It can affect, your ability to serve as a fiduciary in the future. But there's other, ramifications, particularly civil and criminal, ramifications. So, we could spend a whole hour talking about the different civil penalties for breach of fiduciary duty, depending on the type of breach, what kind of position you're in. But generally speaking, if you breach a fiduciary duty as a trustee, a guardian, or personal representative, you're usually subject, depending on the circumstances, whether it was intentional, whether it was negligent, things of that sort, what the trust document says. But generally speaking, you can be responsible for compensatory damages, for punitive damages if it was intentional and requires punitive action, double or treble damages in a certain extent if it's misappropriation and things of that sort, fees, costs of bringing proceedings, and ultimately you can be removed. So those aren't minor potential liabilities. So that's why you should care about how things change and how you have to change in the middle of COVID, because if you don't change, if you don't adhere to the standard of the day, you might find yourself on the bad end of one of these civil proceedings. But what's even worse is a criminal proceeding. I've done a lot of webinars and articles and information lately on the elderly exploitation statute. And sometimes I encounter other lawyers and people in the elderly care field I don't think fully appreciate what that statute says. And I know there's a stated agenda item or a stated policy to really start enforcing the exploitation of elderly statute because it's becoming so prevalent. But I think sometimes people don't realize how fiduciaries can be pulled into that. And what I want to bring your attention to specifically is section 825.103. And that's the exploitation of elderly person or disabled person in the penalties, including criminal penalties section. And I think sometimes people don't understand exploitation. They think it's someone running a scam on an elderly person, and that is covered by the definition, but it's also included in neglect and breaches of fiduciary duties owed elderly persons, also falls under that definition. And I'll give you an example. I mean, exploitation includes, by definition, 825.103, subsection 1, C, breach of fiduciary duty to an elderly person or disabled adult by the person's guardian, trustee, who is an individual, or agent under a power of attorney, which results in an unauthorized appropriation, sale, or transfer of property. An unauthorized appropriation under this paragraph occurs when the elderly person or disabled adult does not receive the reasonably equivalent financial value in goods or services, or when the fiduciary violates any of these duties: committing fraud in obtaining their appointments, abusing their powers, wasting, embezzling, or intentionally mismanaging the assets of the principal or beneficiary, or acting contrary to the principal's sole benefit or best interest. Or in the case of guardians and trustees, who are individuals committing fraud, abusing their powers, or wasting, embezzling, or intentionally mismanaging the assets of the ward or beneficiary of the trust. This would include misappropriating, misusing, or transferring without authorization money belonging to an elderly person or disabled adult from an account in which the elderly person or disabled adult placed the funds, owned the funds, and was the sole contributor. By misappropriation, misuse, or unauthorized transfer. So what I really try to emphasize in that is waste. One of the things is, as a fiduciary, especially if you're managing assets, is you don't want to be seen as wasting assets. You don't want to be seen as wasting potential income and things of that sort. So what happened if in this year and a half of COVID, you didn't have a tenant and you weren't potentially aggressive in getting someone in there because, quite frankly, with COVID and everything else going on in your personal life and everything else you worried about with maybe your with the person that, you know, you're charged with a duty and everything else you were managing for them, that didn't seem all that important. But now, you know, and of course in the time, who knew COVID would still be affecting us 18 months later. But if here in Florida, if you failed to get a tenant, I think it could be argued that in one of the hottest real estate markets we've ever seen in the state of Florida, if you didn't have a tenant and you wasted 18 months of income without, you know, at least, you know, making some effort to get a tenant in there, I'm not so sure that couldn't be waste. And I'm, you know, and certainly with the language in that statute, even though I think it's intended to, you know, to go toward intentional acts and the most egregious abuses, I would be worried if I was accused of waste with that statute. So those are the kind of things why I want to bring these up. I think there's a lot of justification, especially in the beginning. I don't think anybody foresaw that we would still be going on with these kind of limitations in our lives this far in. But certainly now that, you know, you blink and it's been 18 months or more, that these should be issues that fiduciaries and those who advise them should be thinking about. And by the way, criminal remedies, in addition to being charged with a crime, the specific punishments, you know, that go along with criminal penalties, such as, you know, incarceration and fines, you can also be held in contempt of court. You know, you can, and like I said, the criminal remedies under exploitation, neglect, and/or abuse are pretty severe. Those are felony offenses. So those are things to be aware of, and certainly things we should be reviewing when we're advising the fiduciaries, that if they don't think they can adjust to the times and the times we live in and still carry out these duties, maybe they need to rethink that. So, you know, that's a summary now. So far, we've talked about who the fiduciaries are that we have here in Florida typically, and who we're advising, what they need to do, and then now we're starting to look at, well, we've had some different times these last 18 months, and it may have affected their ability to carry out these duties as well as they normally would. And maybe, you know, they had good excuses, maybe not such good excuses, but that's what we find ourselves in. The law recognizes this, you know, society recognizes this. You know, from day one, there's been talk about, well, eventually we'll have some kind of laws that'll come in to protect against liability during COVID, because otherwise people couldn't function, people couldn't have, you know, ran businesses, employers couldn't have told their employees to come back to work if they think there's going to be, you know, some huge liability because of COVID, because we don't. It's hard, especially at that point in the beginning of COVID, to, you know, to foretell and see what all the potential consequences could be of our actions at that time. It sounds fair. But did the legislature actually ever do something? Well, here in Florida, they actually did. And it just passed recently, I think at the end of June. And this is what's become commonly known. What we're going to talk about is Florida's COVID-19 Immunity Shield Law. And it's Chapter 72 or Chapter 2021-1 under the laws of Florida. So I think the first thing we'll look through this, and I'm actually attached a copy of it to the materials here and to the slides so that you can actually read through the statute. I think it's a little misnomer to call it an immunity shield law. I think more, except maybe there's a lot more protection given toward healthcare providers and claims that may be made toward them. But overall, before I delve into the details, I can tell you the overall theme here is actually just putting a higher burden on bringing claims that are COVID-19 related. And of course, COVID-19 related itself is, you know, that term's going to be filled with all kind of interpretation and things of that sort. But I think the goal here was not to write a whole new law or do a blanket immunity. It was to make it more difficult and put a higher burden on any plaintiff who wants to bring a claim against certain parties, which is pretty broad, that relate to COVID. So let's start out. Let's see, well, what is a COVID-19 related claim? It means a civil liability claim against a person, including a natural person, a business entity, an educational institution, a governmental entity, or a religious institution. I'm going to take that as just about anybody. It will fall under one of those definitions, which arises from or is related to COVID-19, otherwise known as the novel coronavirus. The term includes any such claim for damages, injury, or death. Any such claim, no matter how denominated, is a COVID-19 related claim for purposes of this section. The term includes a claim against a healthcare provider only if the claim is excluded from the definition of COVID-19 related claims under section 768.381. Regardless of whether the healthcare provider also meets one or more of the definitions of this subsection. And then there's a definition for educational institution, and I just left that off because it becomes irrelevant to our purposes today. So I want to kind of break this down, and like I said, following we're going to look at, we actually have the whole statute here. It's set out for you, and it creates a section 768.38 Florida statute. I want to look at it specifically in terms of fiduciaries. Can they be subject to what would be termed a COVID-19 related claim and maybe, benefit under this immunity shield law, which is more of a, makes it a harder for a plaintiff to prevail, which we'll look at later. But looking at that broad definition, I'm not so sure fiduciaries can't fall into that. They're individuals usually, sometimes a religious institution or business entities. And I think some of the claims that may be made against them that we discussed earlier, maybe they didn't manage property, maybe they weren't able to make, stay on top of healthcare decisions because they weren't allowed to be there and do certain things. Anything that maybe have been neglectful or wasted during, and COVID was the reason. I think this is meant to be broad enough to maybe perhaps argue that it's a COVID-19 related claim at the end of the day. So it's certainly something I would look at if I was having to defend such a claim. So here's the whole statute, the whole law that was passed. I don't believe it's been codified yet. It won't be codified till probably September, October. But it goes back through the wherefores, the whereas about when the governor passed all these different rules at different sections, and that and that we were limited on certain things. But they acknowledged that it was important for the economy to get back on track, for people to get back to work, and that there were some risks taken in doing that. And so then we get into the actual the meat of it. Get past the thing and past the definitions, and then you start seeing the meat of what it's doing. And like I said, it's not really a blanket immunity so much as it's used to make it harder to bring in action against people if it's related to a COVID-19 claim. Okay, so they have preliminary procedures that are required, as you can see down here in subsection 2. And any civil action against a healthcare provider based on a COVID-19 related claim, the complaint must be pled with particularity by alleging facts in sufficient detail to support each element of the claim, and an affidavit of a physician is not required as part of the pleading. Okay, so this is the section, and I think I told you they're even more stringent against healthcare providers, and then there's other ones that that go against other people, but they all have the preliminary procedure required. They all have a short limitation period. I think they're all 1 year, and with that, and then in the particularity pleading requirement, which is I've seen it, people are interpreting the particularity required of fraud. That's meant to make it a harder burden for any plaintiff to bring a claim. And like I said, they're even more strict on the healthcare provider related things, but related claims. But any claim that is related to COVID-19 falls under this definition. So with all that said, I would take a closer look at this and see if this could apply to your fiduciary. This was the part that I thought might relate to fiduciaries, and I backed it up to this, where it says at the top of this first page here, in a civil action based on COVID-19 related claims, that was that broad definition we looked at, the complaint must be pled with particularity, what everybody's interpreting to mean is the particularity required to a fraud claim. At the same time the complaint is filed, the plaintiff must submit an affidavit signed by a physician actively licensed in the state, which attests to the physician's belief within a reasonable degree of medical certainty that the plaintiff's COVID-19 related damages, injury, or death occurred as a result of the defendant's acts or omissions. The court must determine then, as a matter of law, whether the plaintiff complied with these preliminary requirements. If they didn't, the court has to dismiss it without prejudice. The court must determine whether the defendant made a good faith effort to substantially comply with authoritative or controlling government issued health standards or guidance at the time the cause of action accrued. And during this stage of the proceeding, admissible evidence is limited to evidence tending to demonstrate whether the defendant made such a good faith effort. If the court determines that the defendant made such a good faith effort, the defendant is immune from civil liability. So this is the crux of it. If you acted in good faith, then the court's going to dismiss the action. They're going to deem you immune from civil liability. So that's where I think if you have a fiduciary or no fiduciary that may be accused of causing some kind of harm, and it's COVID-19 related, I think that you can use a statute, maybe perhaps in that defense mechanism, to try to have a preliminary determination whether there was good faith made. And getting back to what we've been talking about through this whole thing is that fiduciaries have had to adjust in a small period of time how they carry out their actions, and they didn't have a lot of guidance. None of us really did. At first, okay, we're not going to be visiting, our elderly clients in the facility, but nobody thought that would be for months on end. And then, nobody thought that, you would continue to have all these restrictions for as long as it happened. And, and nobody saw, the tenant, restriction, the eviction restriction rules lasting, as long as they have. So all those things, if you were showing some effort to react, some effort to try to comply, you're probably going to be able to use a safe harbor or this immunity kind of issue here, at least and overcome the plaintiff's burden there. So that's what I wanted to put out there for people, because other than that, I haven't seen any legislation on the horizon or any discussion about making any kind of blanket rules or specific rules that apply specifically to fiduciaries. So that's our new COVID-19 immunity shield law under the state of Florida. Now there's another safe harbor, and this is where we get back to the practical advice. I've always been of the mind, when in doubt, ask the court. Obviously, this doesn't help trustees as much, but any guardian or personal representative always has the ability to file something with the court, demonstrating that they're attempting to act in good faith. Maybe they're unsure of what they can do under the circumstances, advising the court of the circumstances, asking for guidance, asking for permission to act a certain way. And I think if you get, of course, if you get that order, I think you'll always fall under good faith. If you have a court order that approves whatever plan you came up with, or your inaction or whatever it was that you sought permission to do. And if the court doesn't agree with you, the court can give you direction on what you should do. I think in times of COVID, times of not COVID, asking the court is something that personal representatives and guardians do not do enough of. So certainly now, and even going in the future, I would certainly recommend that. And when you can, advise the court of something unusual going on, something, some snafu that's come up, give them your idea or your plan of response, and get them to either approve it or tell you, no, that's not approved. You need to find another way to do it the way we did it before, or something of that sort. Another big practical advice item may seem simple, but it's effective: communication and diligence. Just don't ignore the problem. I think the folks that might find themselves having to answer some uncomfortable questions are those who just ignored things and didn't communicate during the time of COVID. Just ignored the fact that the house is empty. Just ignored the fact that the market's volatile and the investment director needs managers asking you if you want to do something different. Ignore the fact that there's been tax extensions and you didn't make it down to the accountant on time. Ignore the person in the facility because you're scared and you don't want to go down there, and things of that sort. So those are probably continue to communicate, continue to have some kind of diligence. Is going to go a long way, at least even on the optics. Document some more. If you went down to try to see, the person that you're charged with care of, and you were turned away, good, okay, get them to document that you tried, document that you called, document that you tried to get smartphone into the person and they wouldn't allow it, or try to get something where you could communicate more directly and it wasn't allowed. You know, document that, you know, you reached out to property managers, but nobody wanted to do anything unless they could, you know, have some kind of personal contact and see the facility or see the property, and you weren't comfortable with that for health reasons or what have you. Document, document, document. And finally, don't be afraid to ask the experts. If you know, if you're confused, as a lot of us were at some point in during COVID on what's allowed, what's not allowed, ask, you know, and get documentation. You know, if you have concerns about what's going on and you haven't seen the person, you know, ask a doctor, ask a, you know, a social worker, ask someone who can give you some advice on how can I, instead of getting the answer, I can't see them or I can't do this, how do I get around that? And you know, and if you have, you know, even compensating, you know, professionals for their advice is always wise. You know, I'm confused about the deadlines about these taxes being extended. Now there's something that I don't have to do the required minimum distribution. You know, instead of just throwing your hands up, go ask and find out. If anyone else has anything to add about practical advice, now would be a good time. In conclusion, just don't fall into the COVID trap. You know, don't say, well, it's COVID. It's becoming the catchphrase, you know, here, you know, our little cartoon. It didn't catch a fish. Oh, you know, COVID. We've all fell, you know, we've all fell in that trap. We've all fell to that excuse. But our legal system, especially our system that relates to fiduciaries, the fiduciaries have to push through because someone else, other people are dependent on that. And the whole system falls apart if you just simply say, well, there's COVID, and throw up your hands. So so the whole theme of this has been, don't fall into the COVID trap. Yes, there's going to be snafus. Yes, there's going to be obstacles, but there's always ways to push through. There's avenues to use in either in our statutory code or through other legal means and practical means to get through those. That has my contact information here, has the firm website, our phone number, and my email is phillips@fbl-law.com. If you think of a question or want to share a fact scenario with me afterwards, please feel free to email me or call me. Thank you again for joining us. Have a great day.